make some room.
Everywhere I go, I'm in the spotlight. This is a good life. I'm living bold. This is what it looks like. On the tip of the world.
On October 21st, the Federal Maritime Commission's rulemaking on unreasonable refusal to deal with respect to vessel space accommodations closed. We've covered it a few times here on By Land and By Sea, but there's one notable commenter that I want to highlight today. The Department of Justice has entered the chat. Yeah. Hi, welcome to By Land and By Sea, an attorney breaking down the week in supply chain, presented by the Maritime Professor. That's me. I'm Lauren Beagen, founder of the Maritime Professor and Squall Strategies, and I'm your favorite maritime attorney. Join me every week as we walk through both ocean transport and surface transport topics in the wild world of supply chain. As always, the guidance here is general and for educational purposes only. It should not be construed to be legal advice, and there is no attorney-client privilege created by this video. If you need an attorney, contact an attorney. So before we get into the discussion of the day, let's go through my top 3 stories of the week. All right, so story number 1, we've talked about it before, we're going to talk about it again. The FMC released their detention and demurrage rule. They released that on October 13th. So there's a lot of rules going on here, right? So today, in the meat of the conversation, we're going to talk about the unreasonable refusal to deal rule. That one's closed. The only one that's open right now is the detention and demurrage rule. That opened on October 13th, and it doesn't close until December 13th. So that's a 60-day comment window. Granted, we have Thanksgiving in there, and we have some holidays, but we have a 60 days, October 13th till December 13th, to file and respond to the notice of proposed rulemaking. That really, this detention and demurrage rule is kind of a culmination of a few different things. We've talked about this a lot on By Land and By Sea here. I'm going to keep this on my top 3 stories of the week, but let me kind of explain that. This is a culmination of a few different things. So right now we are in the notice of proposed rulemaking stage. The FMC's put together some language and they've presented it out saying, look, these are probably going to be the things that make it into the final rule. We have one more stage and then this becomes a final rule. So that's what they have out now. They have language that looks like what a rule will look like. Prior to this, we had the advance notice of proposed rulemaking. That was the detention and demurrage advance notice of proposed rulemaking. That was last spring. That was, I think it was April 2021. We covered it on By Land and By Sea then too. In that one, an advance notice of proposed rulemaking is really kind of that. It's advanced. It's early stages. Really, a lot of times the agencies will send out some questions saying, here's what we're thinking. We're going to probably go this direction, but I don't know. What do you guys think? You know, before we start making concrete movement here, we really want to poll the industry. You know, we're the agency for the industry, but you guys are the industry. What do you think? So that's what they did last April. They put out that advance notice of proposed rulemaking, and they got over 80 comments on that. That's great. I love that kind of engagement. And they did a lot with those comments. That's why they have the language now, refined it a little bit based on those comments. Where did the comments support that language? Where did they depart from some of that language from the comments? So advance notice of proposed rulemaking and then the current notice of proposed rulemaking. But we also had a few other factors that went into this detention and demurrage rulemaking that we currently have open now. We have OSRA, the Ocean Shipping Reform Act. So that was Congress getting involved. Congress this summer said, you know, FMC, you know, it'd be good if you guys did a rulemaking on detention and demurrage. And FMC probably said, respectfully, we are. I'm sure Congress knew, right? I'm sure Congress knew. So OSRA came out and gave some directives. We've talked about them at length before, but one of those directives was FMC take on this rulemaking for detention and demurrage. They also said, FMC, we liked what you did on the interpretive rule from May 2020. May 2020, we had just shut down for COVID in the U.S. It was March was basically, I remember it was Friday the 13th of March 2020 that Boston area shut down. How ominous is that? So Friday the 13th. So March 2020, and then by May 2020, FMC had come out with this interpretive rule on detention and demurrage. That's not because they saw what happened in March and April, and they quickly created a rule or a interpretive rule. They had been working on that for a while. So just actually great timing that it came out then. But one thing that they said in that detention and demurrage interpretive rule back in May of 2020 was that the incentive principle should rule the day, is something that they support. The detention and demurrage should be used. This is from the FMC, essentially, paraphrase. The FMC said detention and demurrage should be used to incentivize the movement of goods. They had a little mention of, okay, operational considerations, sure, D&D can be used for that as well, and we get that, but that's not the bulk of what it should be used for. I've said this a lot before, I'm going to say it again. It shouldn't be a line on your P&L. It shouldn't be something that you're expecting detention and demurrage to come from. It really is supposed to be found money, right? So that's kind of what the FMC was saying, that this incentivization principle. And so OSRA took that incentivization principle and put it into law. They turned it around. It became a reg, and now it's under 545 of 46 CFR. So that built in to the current detention and demurrage NPRM. So here we are. This is the moment. This detention and demurrage rulemaking, this notice of proposed rulemaking that we have open right now with the sample language, I mean, this is as close as we're going to get to a final rule before the next step, which will be final rule. So this is your moment. If you really want to weigh in, it's not your last moment, but it's kind of your last likely to make a difference moment. If they set out some final rule language and saying, short of any major objections here, we're going with this, you could still majorly object and they might stop it or amend it or whatever they might do. But really, we've had so many bites at the apple here. This is the last big bite. So take that bite, guys. We need to get all of our thoughts together. The industry across the board, shipper, carrier, OTI, wherever you are in the supply chain, you should have an interest in this rulemaking and you should be watching it. I'm going to keep it on my top 3 stories of the day. That wasn't even the meat of what we're talking about today. Okay, so story number 2. We've talked about this before, but I just want to bring it back up. FMC has been awarded a $500,000 contract to the National Academies of Science to conduct a study examining intermodal chassis pools and provide recommendations on best practices for their management. We've talked about that. That was something that the Ocean Shipping Reform Act of 2022 directed the FMC to do. So National Academies of Science, you might be more familiar with the Transportation Research Board. That is who in the NAS has been given this contract. So Transportation Research Board, they do a lot across the board for studies in supply chain. But one of the things that I wanted to highlight is they are calling for committee members at this point. They are opening up to those individuals interested in serving on the study committee or in suggesting candidates. Reach out to the National Academies of Science Transportation Research Board. They are looking for people. If you deal with chassis, chassis are a problem for a lot of people, right? Chassis shortages. If you are part of the industry, they want to hear from you. This is a study that's supposed to be kind of taking inventory of everything that's going on out there and come up with some suggestions. This is a great moment. The information's on the FMC website, but I can post it here as well. Wouldn't that be kind of cool? These committees are great ways of really affecting that change. So story number 3, we're off to a huge start here, right? So story number 3, we are continuing to watch the rates drop, but actually it looks like they're starting to level off. I've been hearing reports this week saying, they're starting to kind of level off. So I kind of have 2 theories about this. One, there's a lot of people saying, okay, these blank sailings are going up, which is basically, operational considerations usually, or reportedly, or what it's being said, that a vessel might skip a port. And so that's called a blank sailings. And sometimes they're done for operational purposes. Sometimes it's been alleged that they're done for rate manipulation and creating artificial kind of tension or artificial scarcity in the market. So that's been going around. So, we might see more blank sailings or I guess people were saying that, I know that people were saying that blank sailings were on the rise for all of those reasons. But, I didn't see them incredibly on the rise, and I didn't see that as being this huge, salacious storyline. It certainly was around that they were blank sailings. But my second thought on this is that maybe maybe some of these rates were actually being allowed to drop without much interference. I don't know, to help drive out some of those new players, right? We've talked about that before, that sometimes, that at the height of all of this, you could get $20,000 for a box from China to the West Coast. There were some new players that came into the world being like, okay, great, $20,000, I'm in. And that's partly why the unreasonable refusal to deal rule kind of came about. Like they were just categorically excluding exports, and not just these new carriers, but that was one of the concerns. And so, I don't know, maybe it's a conspiracy theory, just a thought. Maybe the rates are being allowed to drop out because those companies that came in under $20,000 now can't support, or maybe the long game is that they can't support when the downturn happens. It was too big to fail for a long time, and then we saw Hanjin go out, the Korea-based carrier. I don't know. I don't know. I'm just a thought. There's a lot of kind of study of what happened, what will happen, and certainly once we get kind of, 5-10 years away from this, it'd be so fascinating to look back and kind of dissect all of this. But maybe that's true, maybe not. It's just nice to see the rates coming off of 20,000. Am I right? I mean, and then to see them starting to get back to new normal, leveling out. I think we're going to pendulum swing for a little bit here, but it's interesting to see. So let's get into the meat and potatoes of the day. We are revisiting the unreasonable refusal to deal or negotiate with respect to vessel space accommodations provided by an ocean carrier. Just as kind of a background so that we're all on the same page, go check out my podcast on this, my episode. But here's kind of the general. So these were released on September 13th and published in the Federal Register on September 21st. So even though they're released by an agency on a certain day, 30-day or 60-day, whatever the comment period starts, the day that it actually goes into the Federal Register. So sometimes it'll say September 13th as they post on the website, and it'll say 30 days from Federal Register publication. So you're not going to know. I mean, it's going to be like 30 days plus some change is usually how it works. So that's what happened here. So the 13th, it was published on the website. The 21st, it actually got published in the Federal Register. So then that meant that comments were due October 21st, which worked out because that was a Friday. So last I reported on this, there were actually only 2 comments filed, and one of them was for an extension of time. So, look, the whole rule has to finish up by December 16th. This was the first rule that Congress, through OSRA, told the FMC to undertake. They said within 30 days, start working on this rule, initiate. But then they also said you got to have this rule totally buttoned up within 6 months. So OSRA was signed June 16th. Now we're looking at December 16th for when this rule has to be totally finished. I mean, I don't know. This is a huge rule. So, okay. So like I said, this was all part of OSRA. There were 3 rulemakings. We've talked about this a lot, but the first rulemaking was this unreasonable refusal to deal with respect to vessel space. The second one that we talked in the intro, detention to merge prohibited practices. There's a third one that we're still waiting on. I mean, if you think this is hot, right? There's a lot going on. There's another one coming, which is unfair or unjust discriminatory methods. I'm so interested to see what that one looks like. I mean, to me, that one is really... I've heard that shippers can be a little afraid or apprehensive of really speaking out against carriers because there's only so many out there, right? I mean, it's just not okay to blacklist anybody, right? It's not okay to put anybody on we don't deal with you anymore because you spoke up. That's what the FMC, I think, is going to be getting at with this. Unfair or unjust discriminatory methods. You can't unjustly discriminate against somebody because they spoke up against you because you were doing something wrong. That, I think, is the crux of what they're going to get to, and that one's going to, I mean, that's going to be juicy, right? I don't know. It's going to be a law. It's going to be a regulation, but I think that's kind of juicy. So that's the third rulemaking that we have not hit yet. So the first 2, unreasonable refusal to deal, that's what we're talking about today, detention to merge, currently open. So unreasonable refusal to deal or negotiate with respect to vessel space. So they are proposing through this notice of proposed rulemaking, is which stage this is, defining certain elements to establish a violation and criteria it will consider in assessing reasonableness. And so the FMC went through vessel space accommodations, refusal to deal or negotiate, saying that it's evaluated on a case-by-case basis. But then reasonableness was the interesting one, basically saying that The FMC has previously found reasonable those decisions that are connected to a legitimate business decision or motivated by legitimate transportation factors, and that a just and reasonable practice is one otherwise lawful but not excessive and suited to the end in view. So to me, that's very fact intensive. That's very, we're going to kind of similar case by case basis, but here's some notions that we're setting out there, but really this is case by case. So I always point this out, but the example that the FMC gave was that a common carrier's repeated refusal to respond to email or telephone requests for negotiation over an extended period of time may be viewed as an unreasonable method of shutting another party out. So that is, you're trying to negotiate, you're trying to enter into discussions here on just moving your goods, and they're not answering the phone or they're not responding to email. We've seen that in the detention and demurrage rule, but or world. I shouldn't say rule. It's not in the rule there, but it is in the rule here on reasonable refusal to deal or negotiate with respect to vessel space. That's interesting, right? That kind of behavior, I think we've seen a few different times. You got to answer emails, right? You got to answer your telephones. So the FMC brought that up as something that they were keying in on as a unreasonable method of shutting another party out. They also talked about a burden shift of rationale for not accepting cargo to carrier. The ocean common carrier must establish that its refusal to deal or negotiate with respect to vessel space, which in some cases results in a decision not to accept cargo, was reasonable. So now it's not the person bringing the suit. It's the ocean carrier. It's not the shipper. It's the carrier who needs to defend that the decision that they made, whatever it was, this refusal to deal or negotiate, was reasonable. That's an interesting shift. And I don't think that the FMC is just going to accept, well, we thought it was, so. Right? I don't think that you're gonna see a lot of carriers just saying, well, of course it was reasonable, right? They're gonna have to support that and back it up. So the FMC doesn't give a ton of prescriptive language here, but maybe that's gonna come out through case law. They did say a situation where an ocean common carrier categorically excludes U.S. exports from its backhaul trip will create a presumption of an unreasonable refusal to deal. So basically they're saying categorically excluding exports creates a categorical unreasonable refusal to deal in the FMC's eyes. They also said they made sure to note the reasonableness in business. So and I quote, the role of the commission, here's the quote. Role is to not ensure that all interested parties get the same deal or make a certain profit. Rather, the commission's role is to ensure that parties are not precluded from obtaining preferential treatment due to unreasonable or unjustly discriminatory reasons. So, they're not going to be in the business of calling winners or losers, but they do want to kind of weigh in here and clean some of this up. So that's what the rule said. And I just wanted to kind of baseline our understanding here. So now we have 27 comments in. Like I said, previously we only saw 2 comments. Now we have 27 comments in. And one of them was from the United States Department of Justice. Yes, the U.S. Department of Justice. You should have heard me reading the list. I was sitting here looking through. I'm like, okay, World Shipping Council, yep. Okay, Tyson Food, AgTC, okay, reading. And then I was like, oh my God, the U.S. Department of Justice? I said, holy cow. I might not have said cow, but I was like, holy shoot. It's not necessarily common for the DOJ to I'm sure they do it plenty of times. I have not seen it come through on many FMC comments, open comment series. I don't know. It's no big deal maybe, but that seems pretty big. I've actually been seeing a lot more of agencies commenting on other agencies' open comment periods and kind of going on record that way. I like it. It certainly shows to me that the agencies are paying attention to what each other's doing. That's important, right? We want to make sure that we're not duplicative in our rules. We don't have 3 different rules saying the same thing. I don't think that that's necessarily a problem here. FMC clearly has the authority over Shipping Act and the antitrust immunities provided under the Shipping Act. But, DOJ still does antitrust generally. And so where it's not in the Shipping Act, DOJ has an interest here. So what did they say? So I'm going to quote some things and then I'm going to kind of respond to it. So, they generally said that they kind of agree with what the FMC is doing here, but they really kind of wanted to provide some suggestions on creating more specificity, some more clarity, some more just really, like I said, specifics of what some of these things mean. So I quote, the division agrees, so division is the DOJ, it's the antitrust division. So the division agrees with the commission's commitment to the principle that, and they quoted from the FMC, reasonableness is necessarily a case-by-case determination, and that, end quote, and that whether a refusal to either deal or negotiate with respective vessel space accommodations is unreasonable must be evaluated on as the FMC said, on a case-by-case basis with particular attention paid to the relevant circumstances. So they're kind of just saying, yep, we agree. Okay, we see that. Case-by-case determination, relevant circumstances, sure. Continuing the quote from DOJ, the division also agrees that the phrase refusal to deal or negotiate does not lend itself to a general definition and instead must be evaluated on a case-by-case basis. Sure, so they're kind of reiterating. However, the division has identified the following areas in which the proposed rule could benefit from additional clarity. That's such a nice way to say, we have some thoughts, FMC. We think you didn't go far enough here. Let me help you with that. That's a nice thing to do. So, and of course, the DOJ is going to be dealing in specificity. You know, I think that the FMC recognized these are tough things to identify and to, certainly refusal to deal or negotiate it can be kind of squishy, right? Like it can be kind of this amorphous, like what exactly, obviously you have your extremes, but like what happens in that day-to-day, that becomes this unreasonable versus just a business practice. And I think that the FMC was trying to balance that, but I'm really encouraged by some of these comments trying to help define that. So, all right, so the DOJ continues. First, the division is concerned that as currently formulated, the standard for establishing the second and third elements of a prima facie case. So they're kind of going into the different elements. They're saying that some of these elements that the FMC put out there may be too high risk and may risk killing off meritorious claims. So legitimate claims of unreasonable refusals to deal or negotiate with respect to vessel space accommodations. So DOJ, I kind of paraphrase that, obviously. Those are my words. Now I'm going to go back to the quote. The summary of the proposed rule suggests that in the first instance, the complainant, so that's the person who brings the claim, the complainant, must prove an actual refusal to even entertain the proposal. So they're saying you have to even tell what happened. You have to prove the actual refusal to even entertain the proposal in how the proposed rule reads. So the DOJ continues, in the division's view, while this may be a sufficient showing, it should not be treated as a necessary one. And this kind of goes back to them saying, we don't want to lose legitimate cases because you had to get over this proving the whole case right off the bat. They're saying that because the section that they're dealing with of the Shipping Act is very fact-intensive and cases-specific, the division cautions against ruling out the possibility that in some cases, an unanswered request to negotiate or deal in good faith could constitute an unreasonable refusal within the meaning of the statute. So this is getting a little slicey-dicey. Okay, of course, that was the example that the FMC gave, right? That not answering the phone, unanswered request to negotiate or deal was one of the examples of what is unreasonable. But they're tying it to kind of this element of this unreasonable refusal to deal or negotiate. I think that the FMC kind of got it, but I appreciate the precision that the DOJ is trying to kind of highlight here, which I think will just find its way into the next stage, the final rule, where maybe the DOJ is saying it shouldn't be a necessary element. It should just be one of the elements and kind of part of the overall story. Like I said, this is getting a little kind of legalese, but, trying to break it down. That's what I do, right? I'm breaking down the week in supply chain from a lawyer's perspective. If nobody can understand the lawyers, nobody wins, right? Lawyers talk to lawyers, but everybody's got to understand what's going on here. So that's what I'm trying to do. All right, so hopping back into the DOJ's, so that was kind of point one. They wanted to say, look, you shouldn't be able to kick out a case because nobody answered the phone and it doesn't quite rise to the level of slam dunk, this is unreasonable refusal to deal. So they continue on. they're saying that the law is presented arguably, there's two categories of conduct, unreasonable refusal to deal and unreasonable refusal to negotiate. So they're saying there's kind of two key words in this rule, right? So we have unreasonable refusal to deal and unreasonable refusal to negotiate with respect to vessel space. DOJ makes a good point here, and they say neither of those two key words, deal or negotiate, are actually defined by statute or even within the Commission's proposed rule. So the DOJ continues, indeed, the proposed rule appears to conflate the terms. It states that it is important to clarify that the proposed rule concerns the negotiations or discussions that lead up to a decision about whether an import or export load is accepted for transportation. DOJ continues, basic principles of statutory interpretation weigh against presuming that deal and negotiate mean the same thing. And this is where DOJ does what DOJ does. They say, as the Supreme Court has made clear, the word or is almost always disjunctive. That is, the word it connects are to be given separate meanings. The division notes that under the antitrust laws, these two terms have different meanings. Negotiate refers to the discussion about a particular transaction, while deal typically refers to the transaction itself, whether it be the provision of goods or services. Continuing on, the division encourages the Commission to address whether the words deal and negotiate under the Shipping Act section should be given separate meanings, and if so, to define those terms in the Commission's rule. A fair point, right? That's a fair point. It's funny because deal, negotiate, this is where we could all describe what that means, but in law, it's so important what those definitions are, because then you start slicing and dicing the definitions to find, does this count or does this not? That's some great background research that DOJ just provided to the FMC so that they can move forward and say, all right, cool, we'll bring that in. And of course, DOJ has properly cited all of their references. So, that's easy, right? Now FMC can say, okay, well, I'm going to pull up that case, I'm going to pull up that case, I'm going to bring in that information, and then apply it to supply chain. I think that's pretty good. I appreciate that the FMC made the rulemaking generally not too overly legalistic. It was approachable. I feel like anybody could read it because they want to make sure that the American public and certainly the supply chain of the U.S. consumer, importer, and exporter are all able to not only read it, but submit comments on it. I think that's good. So I'm going to continue on here. The DOJ recommends the proposed rule specify in the text of the rule itself conduct or factors that constitute an unreasonable refusal. They're basically saying, look, you gave one little example, but we're going to need some more factors or examples. It says, for example, the Commission's summary of the rule states, the Commission presumes that every ocean carrier operating in the U.S. market will have the ability to transport exports in addition to imports until further information is provided. So that's, okay, that's they're summarizing what the FMC had said, and that any ocean carrier may not categorically exclude U.S. exports from a backhaul trip without showing how this action is reasonable. DOJ, that was the end of the quote of the DOJ quoting the FMC. It's all good. All right, let's continue. So DOJ specifically quote here. I'm gonna quote them. The text of the rule should make clear that a presumption of an unreasonable refusal will apply under these circumstances. The text of the rule should make clear that a presumption of an unreasonable refusal. So if you're assuming or presuming an unreasonable refusal will apply in categorical exclusions. Yeah, that's a great way of saying, okay, categorically excluding, we're going to say categorically unreasonable. DOJ continues, in addition to clarifying the circumstances under which a refusal is presumptively unlawful, the Commission should clarify each of these expressly enumerated factors the Commission deems relevant in addressing reasonableness. So they're now getting back to quoting the FMC, where the FMC outlined three different factors that the FMC is considering in their reasonableness. So the FMC, DOJ is quoting the FMC, but the FMC rule here says that the first factor is whether the ocean common carrier follows a documented export strategy that enables the efficient movement of export cargo. So they're kind of saying, do you have an export strategy and what isn't? Factor 2, whether the ocean common carrier engaged in good faith negotiations and made business decisions that were subsequently applied in a fair and consistent manner. Okay, maybe you don't have an export strategy, but were you still kind of did you give them a chance, or did you talk about it, and then did you say, you know what, we just don't have the space for it. We don't have we already have empties going on that line, or we already have overly full containers. These are heavy containers going out, and so we can't bring in as much as we take out because you got to balance the vessel out, right? That's just general operation. You got to kind of balance out that weight balance. Even though they're enormous, even though they're like skyscrapers on the water, they still have balance and weight requirements associated with these huge carriers. So that's 2, the good faith negotiations. And 3 is the existence of legitimate transportation factors. So the FMC highlighted those 3 factors. And that third one is the existence of legitimate transportation factors. DOJ is highlighting this because they say the division strongly encourages the commission to explain what is qualified as a documented export strategy. So like what constitutes that. That one's tough because that can change, but maybe they provide some examples of what they probably think are export strategies. In assessing reasonableness, and also adopt the certification requirement it seeks to comment on but did not include in the text of the proposal rule. So documented export strategy, like what are you looking for? What certification or what documents are you looking for in this export strategy? DOJ, I mean, this is all clarifying the whole thing. So DOJ says the commission should consider clarifying that the mere existence of either a documented export strategy or legitimate transportation factors are insufficient to immunize an ocean carrier from liability. So they need to clarify that. They're basically just saying, look, all of these things need to be clarified. They're connected with an and. And okay, so let me talk through that a little bit. So I say they're connected with an and. So the 3 factors, the documented export strategy, the good faith negotiations, and the existence of legitimate transportation factors. Those factors deemed relevant they're connected with an and, meaning usually if they're connected with an and, I mean, like I said, this is getting so legal, like slicing and dicing words, but I mean, all right. So in general, this is a non-legal audience. This is almost like the workings of a law brain, that an and can be so important. Does it connect or does it dissect the factors together? This one is an and. And the DOJ is saying, consider clarifying that the mere existence of either a documented export strategy or legitimate factors are insufficient to immunize the ocean carrier from liability. Meaning that that if those if they do have an export strategy, just the fact that they have one is not necessarily good enough to say that it was reasonable. They're just kind of saying, clarify that, look, I have this export strategy, and on it says, deny all exports. I mean, that's not necessarily reasonable, right? And that's what DOJ is saying here. Like, the actual content of that export strategy, documented export strategy, might be junk. Or I mean, I shouldn't say junk, might be unreasonable. So that's kind of what they're saying there. And then it says, continuing on with DOJ's comments, finally, the division encourages the commission to consider whether there may be additional factors or indicia, factors that it should expressly address in setting forth the standard for determining whether an ocean common carrier has unreasonably refused to deal or negotiate with a shipper. They're saying there should be additional factors in setting that standard. For example, DOJ continues, the commission might consider whether under certain circumstances, ceasing a profitable prior course of dealing with a shipper could be an indicator of unreasonableness. In addition, although the notice of proposed rulemaking suggests that commercial convenience alone is not a reasonable basis for a common carrier's refusal to deal and negotiate. So they're saying commercial convenience. So saying, we just can't, that's not going to be a reasonable basis for a common carrier's refusal to deal. The DOJ continues, the commission should consider whether an ocean common carrier's refusal of profitable accommodations for available vessel space without explanation or justification in some cases serve as an important factor to consider in assessing reasonableness. So like if the carrier says, I was going to lose a lot of money, so of course I'm not going to take those. Is that an important factor to consider? I think it's certainly one of the factors. I don't think that the FMC is going to run anybody out of business requiring carriers to take losses, but I do think that that needs to be part of the decision, right? That needs to be part of the justification for whether this was reasonable. And what DOJ is saying here, how much weight are you going to give that? I don't know if they even know that yet, how much weight they're going to give that. But I think that it's important to maybe highlight that, maybe add another sentence or two in the final rule that just says this is one of those things. Like I said, they're not calling winners and losers, and that's what the FMC tried to make clear. Maybe here the DOJ is just suggesting that they make that a little bit more clear. So continuing on with the comments from DOJ, the division also recommends that the commission consider the extent and sufficiency of remedial measures that an ocean common carrier took following refusal to deal. So they continue on. An ocean common carrier that refuses to deal with a shipper but offers restitution for failing to make the shipment or helps to secure a suitable replacement vessel for the shipper's good may indicate that the carrier was acting in good faith. Conversely, a refusal to deal and an outright refusal to engage in any remedial action should be weighed against a carrier in any adjudication regarding the reasonableness of such a refusal. Such a consideration would help to promote pro-competitive behavior in the shipping industry and better realize the goal of protecting shippers and promoting exports. I love that suggestion. I think that that's great. So what they're saying here, an ocean common carrier basically says, I can't take your load. I can't take your shipment right now. I just can't. Maybe they have a real reason. Maybe they don't. That will be determined. But the DOJ is saying, if they said, I can't take the load, but I do have a friend, not a friend, it's like the alliance or whatever. They're going to say, but I do have another vessel, or I do have, I can help you arrange for somebody else to take it. So like you can't hop on the, we'll throw it into the airlines. You can't hop on the 2 p.m. flight, but there's a 5 p.m. flight next terminal over. Maybe they're in the same alliance, maybe they're not. I'm going to help you rebook onto that 5 p.m. flight. That's kind of what they're saying. And aren't airline examples so much easier to help explain because it's so commercial facing, it's so customer facing that I think we can all kind of understand that. And I did an episode on that comparing airline alliances to ocean carrier alliances. But anyway, so that's what they're saying here. Did the ocean carrier, after they said, sorry, can't help you, try to help? Try to say, I can't help you, but let me see if I can get the goods somewhere else. Or did they just say, nope, can't help you? The DOJ is saying, look, let's put that into the rulemaking language here and see if that's something that should be considered. That would be like a gold star, right? Or at least like a partial gold star. And as you're building the full discussion, that's something to put into the full discussion. And I really like that DOJ said such a consideration would help to promote pro-competitive behavior. That's what the whole game is about, right? That's the FMC is here to help increase that competition, to be weary of any sort of discriminatory, unfair practices. They are for the fair and efficient movement of goods and cargo over ocean-borne cargo. And I think that would also, help encourage so that the ocean carrier can say, oh, I know that the FMC tends to look favorably on me trying to make sure that this load needs to move. Like, that's the whole point. We need to make sure that this cargo gets moving. So if you can't take it, try to get somebody else to take it or help. I don't know what that looks like in the operations, because then you start to get into, are they competitors working together? But I think that there's something to be said for, as the DOJ says, the restitution here. But the helping the guys out, all right, helping the shippers out. I think that these are really good comments, right? I like these overall. I think that this is a really good way in. It's forcing precision, I think, and maybe there was some clarifying. And, they're not uneducated, obviously, on the general world that the FMC is coming from, but they're kind of an outside voice saying, here's some things that, we just want it cleared up a little bit. So I think those are good comments. And actually, I've been really jazzed about a lot of the comments that came in. I was going to cover a lot of the comments today, ended up just going for DOJ because I was so pumped that they had submitted comments. So we're going to be covering some of the other comments through the next couple of weeks. We're going to keep D&D on our top 3 stories of the week. But we're also going to be kind of slowly going through some of these comments and just talking about what people have said. There's been some really, really interesting stuff brought up. And the FMC has to close this rule by December 16th, you guys. They're under the gun. And we have Thanksgiving. And, I've said this before, but they can't just, it doesn't just go to the OGC's, the Office of the General Counsel's office. They write all this up and they're like, okay, that's good. It needs to circle around all the commissioners. Like, they all need to weigh in. They talk about it. There might be a general hearing because the commissioners can't all get in the same room together. They can't have, more than two essentially get in the same room together. Otherwise, it has to be a Sunshine Act. Otherwise, it has to be like a full public hearing. So that's where we're at. I mean, it's about to get exciting, and I'll keep you updated. Look, as always, the guidance here is general and for educational purposes. It should not be construed to be legal advice directly related to your matter. If you need an attorney, contact an attorney. We went into some detail of legal stuff today. No guidance, just general education. But if you have specific legal questions, feel free to reach out to me at my legal company, my law firm, Squall Strategies. Otherwise, for the non-legal questions, for the e-learning and the general industry information and insights, come find me at the Maritime Professor. If you like these videos, let me know. Comment, like, and share. Send them out to your friends. If you want to listen to these episodes on demand, or if you missed any of the previous episodes, check out my podcast, By Land and by Sea. If you prefer to see the video, you want to see my face, they live on my YouTube page, By Land and by Sea, presented by the Maritime Professor. And while you're at it, check out the website, themaritimeprofessor.com. We have e-courses that are being built, and they are dropping soon. I'm so pumped. So until next week, this is Lauren Beagen, the Maritime Professor, and you've just listened to By Land and by Sea. See you next time.